Hello Mission Control. Did you know that mortgages are a necessary part of our modern society? Most commonly, it is used to raise enough capital in purchasing a house or land and as a security for loan repayment. In this video, the focus shall be on the question of to what extent that the current law on foreclosure, possession, and sale strikes as an appropriate balance in protecting the interests of mortgagee and mortgager, while at the same time providing some guidance to Mr. and Mrs. Horton, especially when COVID-19 is rampant today. So, let's get started.
Guiminji, the coronavirus pandemic has led to a loss of employment and loss of income for many mortgagors. In the most common situation where a mortgagor failed to pay an interest rate, the mortgagee may foreclose or may obtain possession in the court and sell the property to recover the outstanding loan. Before we discuss how the current law on foreclosure, possession, and sale strike an appropriate balance in protecting the interests of mortgagee and mortgager in this video, I'm going to discuss what kind of interest rate is conscionable. Fixed rate mortgage, a mortgage loan for which the interest rate remains constant through the term of the loan. In contrast, variable rate mortgage, a mortgage loan for which the interest rate is adjusted periodically, typically in line with some major short-term interest rate. I'm going to focus on variable rate mortgage in this video. Based on the scenario video, we can notice the mortgager claimed that the rate suddenly jumped so high. Even though the rate is adjustable, it is important to know that the rate must be conscionable. A court has the power to strike down any term of a mortgage or indeed the whole mortgage where it is the result of an unconscionable bargain. An example is an interest rate at such a high level that it renders the equity of redemption valueless, and explained in City Land Property Act number 1968. In this case, the lender requires a premium of 57% of the amount of the loan repayable over 6 years. Govjasi held that the collateral advantages was unreasonable in the circumstance and was invalid. The Court of Appeal in Paragon Finance Limited and Nash 2002 has held that there is an implied term in every mortgage that the discretion to vary interest rate should not be exercised dishonestly for an improper purpose or arbitrarily. Moreover, in the same case, although the average lender is not a charitable institution, the court expressly imported the analogy of Wednesbury reasonableness in confirming that lenders are subject to an implied term that they should not set rate of interest unreasonably. Hence, they should not exercise discretion in the way that no reasonable lender acting reasonably would do. However, in exercising this jurisdiction, the court is not concerned with excusing a mortgagor from the consequences of a bad bargain, especially if they have had the benefit of legal advice. Such a deal is the mortgagor on a fair and a bad bargain, or Hamptons, do not necessarily make an unconscionable mortgage. This is clearly shown in Johnson Morgan's 2001. Besides, the unfair terms in Consumer Contract Regulation 1999 also accept that an interest rate in a mortgage will not be unfair because it's fluctuating, provided that the lender gives notice to the borrower of any change, and the borrower is able to redeem if he or she so wish. In short, the traditional strict approach in equity has been to relieve the borrower of isolation only when the mortgagee has engaged in fraud, bad faith, or other conduct, making oscillations unconscionable. The strict approach, which focuses on lender misconduct, leave unprotected certain circumstances beyond the mortgager control, such as presumably recent job loss in this pandemic, even when the isolation will cause certain hardship. If the lender is not guilty of misconduct, the lender may rely on the strict terms of the contract to invoke isolation and foreclose upon default, however harsh the consequence.
This is Speaker Sin, and I'll be talking about the right to foreclosure. In the UK, foreclosure is a traditional remedy for the mortgagee which is rarely used today. In the case of POC and Mortgage Services Funding PLC, Sir David Nichols pointed out that foreclosure actions are almost unheard of today and have been so far for many years. Mortgagers prefer to exercise other remedies. In determining the extent in which the current law of foreclosure strikes a balance in the protection of the interests of the mortgagee and the mortgager, the law and functioning of foreclosure shall first be examined. There are two steps in a foreclosure order: the foreclosure nisi and the foreclosure absolute. Foreclosure nisi provides the mortgager with a 6-month period in raising money to pay off the loan to the mortgagee. However, if the mortgager fails in repayment, their right to the property will be extinguished. Absolutely. Thus, foreclosure absolute. Under Section 88(2) of the Law of Property Act 1925, the effect of the foreclosure absolute will result in the vesting of the mortgager's estate in the mortgagee and the extinguishing of the mortgage and the terms of the mortgage. It should also be noted that a court order is necessary when relying on the remedy of foreclosure, as seen in the case of Re Farno Eads, Irvine and Co., and that foreclosure cannot be sought before the contractual obligation to repay to be broken, as seen in the case of Williams and Morgan. With a shift in focus from a more contract-based to a more equity-based law of mortgages, the rather strict and rigid manner of foreclosure becomes less popular. Foreclosure in equity is basically where the court simply removed the stop it had itself put on, which is a remedy that was once utilized when the mortgager situation is dire and the repayment of the debt is highly unlikely, which the court has no choice but to grant foreclosure despite it not being conforming with equity's principle. Furthermore, in Shukurova Finance and Alpha Telecom, it was held that there is a residual equitable discretion to grant relief from such forfeiture when considering enforcement of security, which resulted in transfer of ownership from the mortgager to the mortgagee, when there is the unlikely event that the mortgagee seeks for the remedy of foreclosure. It is submitted that in balancing the rights for both the mortgagee and the mortgager, foreclosure is ultimately not a preferred option by both parties. By looking at the mortgager's point of view, an order of sale is a better option in many cases, especially when they are facing financial hardships and are unable to repay the loan and redeem. The court's right to direct a sale is enshrined under Section 91(2) of the LPA 1925 and in POC and Mortgage Services. This issue is brought into light where the court held that they could not decline a direct sale if the alternative of foreclosure would ultimately manifest unfairness, as it would be unjust and inequitable. Therefore, the courts would not hesitate the direction of sale in most situations, which produces a better financial result for the mortgager, making foreclosure losing its purpose. In Mr. and Mrs. Horton's case, this option is a more advantageous and fair to them, as it allows for the mortgagee, which is the bank, to keep the portion of the proceedings from the sale which represents the debts, interests and costs, with the balance being entitled by the mortgagors or other mortgagees. On the other hand, from the perspective of the mortgagee, the law of foreclosure, despite being called absolute, the court may reopen the whole situation and allow the mortgagor to redeem the property. In Campbell and Holyland, an order for foreclosure has been reopened 3 months after it had been deemed absolute. From the above, it can be seen that foreclosure does not provide a balance to the mortgagee and the mortgagor, but rather advantages towards the mortgagor instead, due to the fact that the order of sale can be made as an alternative of foreclosure and the lack of finality for the foreclosure absolute. For the mortgagor, however, it has also highlighted the fact that foreclosure has no place as a remedy today, as it is not a preferred option by both parties due to its draconian nature, with the order of sale being a more preferred alternative. Thank you.
Hello, my name is Hasha Akila. I will continue on by explaining the right to possession. This is one of the most important rights of the mortgagee, and this can be proven in the case of Formate and Dudley Marshall. The court has the power to postpone or suspend the possession as stated under Section 36 of the Administration of Justice Act 1970. However, this discretion can only be applied if the mortgagee brings an action to the court. A good example regarding this matter can be found in the case of Barclays Bank. This case explains the relationship between the mortgagee's right to possession of the mortgage property due to default by the mortgagor itself and the court's discretion to defer or suspend the right. The case was regarding a bank, the mortgagee, exercising the right to possession of the mortgagee's property without bringing an action to the court. The Court of Appeal held that the possession was legitimate, as there was nothing in the 1970 Act that could rescind the mortgagee's right. The possession was still valid even though the bank did not seek an order. If the mortgagee seeks an order from the court to possession, then it will fall under Section 36 of the 1970 Act as amended by Section 8 of the Administration of Justice Act 1973, where the court has the power to withdraw, suspend, or even postpone the possession if the court sees that the mortgagor has the potential to pay the remaining debt. However, if the mortgagor fails to convince the court can do nothing about it. Nevertheless, mortgagees seeking for possession of the mortgage property usually have no intention to possess the property. Instead, they usually do so to ensure that payments are being made by the mortgagor, or they usually possess before the sale of property. In such a situation, when the right to possession is exercised by the mortgagee, they have to provide information to the mortgagor before possession can take place. They have to set out the default of the mortgagor and other things, such as whether the mortgagor is about to lose their house or whether they are able to claim houses from the local authority to ensure that they don't end up being homeless. But if the mortgagor successfully paid the mortgage in full, then this would automatically end the mortgage, and therefore there could be no possession taken by the mortgagee. Prior to the 1970 Act, the courts had limited powers to intervene with the right of possession by the mortgagee. However, this has all changed after they recommended that courts should be given some statutory powers to adjourn the possession of proceedings for only a reasonable period of time, to give a chance to the mortgagor to pay the debt. This recommendation can be found under the section stated previously. In the case of National and Provincial Building Society and Lloyd, it was held that the question of reasonable period would be a question for the courts to decide themselves. However, it can be said to a certain extent that this right to possession also brings some disadvantages to the mortgagee itself. This is because if there are any shortcomings, then it could be said that the mortgagee is in debt to the mortgagor. Therefore, mortgagees avoid seeking possession unless they plan to sell the property. So, to relate to the situation faced by Mr. and Mrs. Horton, the bank who acts as the mortgagee has the option of possessing Mr. and Mrs. Horton's house. If they do so by bringing an action to the court, then the couple can try to convince the court to adjourn the possession. However, if the bank did not bring an action to the court, instead they just give notice, then unfortunately the couple cannot do anything about it. That is all from me. Thank you.
Hi, my name is Sabrina Tan. So as mentioned earlier, Section 36 of the Administration of Justice Act 1970 invests in courts with the discretion to grant or suspend an order for possession. In determining this, the courts consider a range of factors, including considering whether the mortgagor can reasonably afford to meet their obligations in the near future. If courts find that the mortgagor is able within a reasonable period to pay any sums due under the mortgage, then courts can provide assistance to mortgagors by exercising their discretion under Section 36 of the Administration of Justice Act. In regards to any sums due, in Halifax Building Society in Clark, the court found that the borrower was required to clear the total sum owed. However, this endangers the purposes of Section 36 because if the borrower was already unable to meet their periodic payment, it would be even harder for them to repay the whole loan. This led to Section 8 of the Administration of Justice Act 1973, which clarifies the area and provided that the term any sums due applies only to arrears which are outstanding at the time in addition to normal contractual payments. If homeowners or mortgagors can show proof that they can afford their obligations in a reasonable period and other loan requirements are fulfilled, then Section 8 would apply for purposes of Section 36, and courts may delay giving a mortgagee possession of the mortgage property so as to allow a reasonable time to pay any sums due under the mortgage. However, what constitutes a reasonable period? The Paying Committee and Parliament envisioned a short period of a year or two to provide the borrower with relief, to allow the borrower to overcome a temporary financial setback such as the loss of a job, illness, or difficulties arising from the COVID-19 pandemic. In Centrex Trustees Limited and Ross, Justice Golding provided that in asserting how long a reasonable period might be, the court must bear in mind the rights and obligations of both parties, including the lender's rights to recover their money by selling the property if necessary, and the full past history of the security. From this, we can observe the efforts in common law in balancing the interests of both mortgagor and mortgagee. Moreover, the Mortgage Conduct of Business Rules, which is MCOB in short, provides in Section 13.3.2a, subsection 3, that if a customer is having payment difficulties, the firm must allow a reasonable time, having particular regard to the need to establish a payment plan which is practical in terms of the circumstances of the customer. However, although the MCOB provides in Section 13.3.2a, subsection 6, that the lender must not repossess the property unless all other reasonable attempts to resolve the possession have failed, Lisa Whitehouse argues that lenders can initiate court proceedings without pursuing other reasonable attempts by seeking for a suspended possession order instead of an outright order. Therefore, lenders could bring an action in court not to seek possession, but to keep the borrower accountable so that the borrower continues to pay off the arrears. Lisa Whitehouse notes that this is detrimental to borrowers because the majority of residential mortgage contracts contain a term which enforces the borrower to pay any costs arising from enforcing the lender's rights under the contract. Therefore, when a lender seeks a suspended possession order to enforce the borrower's payments, the borrower faces more financial burden for each hearing. Despite this unfair right of lenders to impose the cost of each hearing upon the borrower, the courts do not have the power to prevent a lender from adding its costs to the security due to the principle of freedom of contract. Therefore, homeowners or mortgagors facing financial difficulties could possibly rely on Section 636 and Section 8 of the Administration of Justice Act with reference to the MCOB for protection if the matter goes to court. However, mortgagors would have to bear the cost of each proceeding as well, subject to the terms of each mortgage agreement. This shows a balance in the interests of both mortgagor and mortgagee. Thank you.
Hi, I'm Samantha, and I'll be presenting about the balance of rights between mortgagors and mortgagees on the right to sell the mortgage property. Generally, the bargaining power between the mortgagor and the mortgagee is skewed more in favor of the mortgagee due to the fact that mortgagors are the ones who are in need of the financial assistance from the mortgagee. In terms of the mortgagee's right to sell the premise, Section 101 of the LPA 1925 provides that the sale would arise if the mortgage is effected by a deed, the mortgage payment is due, and the agreement allows for the sale of the premise. The said right would become effective when the mortgagor defaulted in 3 months of payment after the notice was given by the mortgagee. The mortgagor defaulted in 2 months of interest, or if the other terms of the mortgage agreement was breached. Based on the scenario video given, if the bank wants to sell Mr. and Mrs. Horton's property, they would have to fulfill the requirements under Section 101 and 103 of the LPA 1925. Besides that, the court will ensure that the mortgagee exercise their duty of care and good faith when selling the property. The duty of care provides a safeguard for the mortgagor to ensure that the sale of the mortgage property was not part of a reckless act, and also serves to prevent the conflict of interest. Next, the mortgagee has a duty of good faith to sell the mortgage property as soon as possible and in an open market value. Judge Matthews in Devon Commercial Property against Barnett added that the lack of good faith must encompass an intentional action of more than just mere negligence, and is also done with bad faith. However, if the selling of the mortgage property was not done properly, then the sale would be set aside and the common law remedy of damages would be provided. In the event where the requirements under Section 101 and 103 are met, the mortgagor would be further protected by Section 36, Sub 1 of the Administration of Justice Act 1970, which was explained by Sabrina and Harsha before this. If the mortgagee is successful in the sale of the mortgage property, Section 105 of the Act provides that all proceeds must be used to pay all of the costs or any subsequent mortgagees, and lastly, the residue of the money would be given to the mortgagor. This not only allows the mortgagee to recover loan money, it also allows the mortgagor to receive the remaining money from the sale. Let's say if the bank managed to sell Mr. and Mrs. Horton's property. The bank would be able to recover the money that they have loaned to the Hortons, and the money left over would be returned to the Hortons. Therefore, it is observed that the law serves to empower the rights of the mortgagor to balance the rights of both the mortgagor and the mortgagee due to the higher bargaining power of the mortgagee. As discussed previously, while the remedy of foreclosure and possession struggles in striking a balance between the mortgagee and the mortgagor's rights, the mortgagee's rights to sell the property provides the most balance between the mortgagor and the mortgagee. Hence, it is one of the reasons why banks usually prefer to exercise their right to sell. Therefore, the right to sell is the better option for banks, and at the same time ensuring that it is not too detrimental to Mr. and Mrs. Horton's rights as mortgagors. That is all, Mission Control. Thank you.